Hi everyone, Zalna here. I received a comment about Fideicommissum in relation to a joint will in the instance when the surviving spouse does not wish to be bound by the joint will any longer. The question was made in response to a video I did about a joint will on my YouTube channel. A fideicommissum is a legal concept wherein a benefit, usually fixed property, is bequeathed or given to one person, but subject to a condition that on the occurrence of a specified event or the fulfillment of a condition, that the inheritance or part thereof is to pass on to another person. For example, person A leaves property to person B on the condition that when person B dies, the property then goes to person C. A joint will can be described as a document which contains the wills of two persons brought together into one will. A joint will is common amongst married persons. Estates of the two parties are massed or consolidated. Massing simply means the bringing together of two estates. The concept of fideicommissum can be created in a will in the following way. So say persons A and B are married and decide to create a joint will, and they bring their estates together. So in terms of the will, they mass and bring their estates, their properties all together. And secondly, A and B decide that should either of them pass away, that joint estate will then go to the surviving spouse. So if A dies, her property goes to B, and should B die, his property goes to A. The condition created is should the survivor of them die, they are now both deceased, then the property of that joint estate goes to C. The question I get a lot is whether this legal arrangement is binding on the surviving spouse. Now there's this principle in our law called freedom of testation. This means that the surviving spouse is not bound to the legal arrangement created by that joint will. Upon the death of one of the spouses, the survivor must then decide whether either to adiate, which means that spouse agrees to be bound by that joint will, or repudiate, indicating that the survivor does not want to be bound by the joint will. This brings me to the question that the person asks: what happens when the survivor does not want to be bound by the joint will? How does that impact the fideicommissum, a legal arrangement created in that joint will? So in terms of the joint will, the wishes of the deceased spouse will be honored. The property of the deceased will go to the surviving spouse, but upon the death of that survivor, the property then goes to the beneficiaries nominated in the joint will. The survivor can make his or her own will if they repudiate the joint will, but they can only dispose of their property and not the massed estate. Bye for now.